Well, good morning, everybody. Nice to see a fellow bearded traveler on the call. Hey, Kayla, how are you?
Doing good.
Good, good, good. We're going to give it just one more minute and then we will kick it off here. Carrie, haven't seen you in a while. Are you going to grace us with video today or not? Not even audio? Savannah's hopping on. There we go. Jessica, good morning. Savannah. All right, we're rolling in, rolling in. All right, while we're letting people queue up real quickly, just normal top of the hour, any wins from last week that anybody had? Wow, you guys got to get out more. There's
I
lots of
had a win.
All right, let's hear it. Who's this? You're just showing his iPhone 258.
Oh, this is Don.
Hey, Don.
Hey, the sellers accepted my buyer's offer out of 9 offers over the weekend.
How did you make that happen?
Just wrote a great offer.
Oh, come on. You got to put a little more flesh on than that. Did you go above
Uh,
list price or just a great
no, we did full price, no concessions, quick close.
That can get it done these days, especially the quick close. I'm finding that in talking with agents, that's carrying a lot of weight these days. Mostly, I think, because a lot of people have either been bounced around a little bit with a previous offer or whatever the case may be, and they don't want to mess around, right? Anybody who's done this long enough and knows their contracts modestly well, we all know the provisions that give people exits to a contract. And so, one of the best things we can do, I think, especially when representing a seller, is articulate those points and be like, listen, a lot of agents don't really comprehend this and understand the ramifications for their seller. Let me explain to you the key portions of a contract. And, specifically, I think the first ones that come to mind are section 8.1, 8.2, and 8.3, as well as seller's disclosures deadline and the actual settlement deadline. And, it's pretty powerful when you can just say to your seller, I'm not the biggest contract geek. I'm just a little bit of a contract geek, but you probably want to pay attention to sections that have at the buyer's sole discretion. That is like the most powerful contract language I think there is. No writing was required. Nothing is required other than they got a wild hair. And that is justified under the term sole discretion. So, very good. All right, we are going to get underway. I'm just going to start with one thing here. It's anybody remember what the challenge was last time? Man, you guys better. What was my challenge to you last time on this call to make part of your weekly routine?
Add
Who said
stats. Add
rapid?
stats to your
Yep,
schedule. Time
that's
block
right.
it.
Rapid stats. So I'm going to share this with you really quickly. We're not going to go through it all again. What I asked you to do is to come into utahrealestate.com, go down here to rapid stats, which will open up that page right there. So we're now talking one click, right? And if you did nothing else, these three across the top tells you where we currently are, but more meaningful. And I did another screenshot so you can see. If you come down and drop these little carrots down to how does this compare versus a year ago, 365 days ago, it will generate this for you. That's it. You can have this done in 5 minutes every Monday. Look at it, digest it, be able to say intelligent things to your sphere, your current clients, buyers, sellers, whatever the case may be. And you not only will look like a genius, you are more of a genius than most, right? And say, gosh, you know what? Active listings are up 28%. Solds are up 5.3% versus a year ago. And under contracts, which we call, here's for those that want the A in the course, your leading indicator, your predictive indicator of where the market's going. If we have any, it's this one. How many are going under contract, right? That tends to indicate where we're going to. trend towards. So under contracts are going up. People are getting more optimistic, and there's also more demand. So again, go here, click Rapid Stats right here on the left-hand side. It'll bring you here, and then just drop down the list on each one of these to 365 days ago, and it will give you that list. Now, the real question is, how many of you made it a calendar item in your Google Calendar or whatever other calendaring you use? If you haven't, you really should. Okay? All right. Didn't want to spend too much time on that because we have a lot of ground to cover today. Let me go here. Last week we did sections 1 through 6 roughly of the purchase contract. And I'm going to, one more quick reminder, make sure you always have the latest up-to-date REPC. A few of you reached out and asked for my marked up copy, and I've gone through and restructured it a little bit to make it flow a little better, and I've added a lot of comments to each of the sections. So once again, if you want this, just reach out to me via email and I'll send you my copy. All right, make sure you have the latest copy, which is December 4th, 2024. That is the latest REPC, okay? All right, I'm gonna zoom in a little more so that everybody can see effectively here. Okay, rapid fashion, because we already covered this last week. We covered the description of the property, what's included, what's not, or what is included, other items included, and more importantly, what is excluded. And just a reminder, an ounce of prevention is worth a pound of cure. If your client remotely hints that they may not want to include something, best to get it here in section 1.3. 1.4 talks about water and what is by default required in the contract. Then, of course, we have the purchase price. These two boxes really absolutely need to match up. If they don't match up, you've done something wrong in calculating your purchase price and the breakdown to the bottom line. Settlement and closing, super important. I think out of section 3, the most important on a regular basis is making sure both clients, buyers and sellers, understand possession, right? I don't know how, I can't tell you how many agents I run across that mostly not in our company, but outside have not put their eyes on apparently section 3.3 and understand what it means. Okay. Prorations and settlements, pretty straightforward. Special assessments, HOA. But then we did spend quite a bit of time on the real estate brokerage compensation. We're not going there today. If you want to rehash on that, go back and watch the training from 2 weeks ago. Confirmation of agency, super important. And these boxes over here, please make sure you check them correctly. If our brokerage is going to be on both sides, or if you're going to be on both sides, make sure the correct boxes are selected. And lastly, by way of review, title and title insurance. We didn't spend, I want to spend 2 seconds here on section 6.1. Now, before I highlight my little note to give you a taste of the notes I've added to this, what is fee title to a property? What does that even mean? Right? Because the seller's representing, they're basically giving a declaration. Yep, I have fee title to the property. And so one is current. I have fee title to the property and I will convey marketable title. There's a reason why those are separated out, and it's pretty significant. Anybody want to give a stab at fee title? All right. Wow. You guys are making this so fun today, and I really appreciate it.
Okay, Matt, I'll take a stab at it.
All right. Thanks, Joyce.
So fee title is going to be a clear, clean, unencumbered title.
I love that.
And of course, it's very likely that we would see a mortgage encumbrance, but it's clearly understood as part of the process that that would be cleared. That's the responsibility of the title company to ensure timely and accurate payoff of that and any others. I'm going to throw in a pitch here and say, as real estate agents, I think it's very common that we receive the title from our title companies and we forward it on. We have to read that because, as an example, years ago, I represented a buyer and there was a bankruptcy recorded And nobody was aware of it until I brought it up. And we did get the deal closed, but as I recall, it involved the real estate agent coming forward with some money of her own. So we have to read those. And
Yeah.
if we don't understand them, that's our title companies are there to interpret them for us.
I've told agents for years, and Savannah and Kenzie on the call, the TCs, I tell them, if you read no other section, then go to that preliminary title report and look at section B2, which is all of the exceptions.
Right.
Right? So just before that section, it has all of the standard things. We're not going to pay taxes. We're not going to, right? There's some standard boilerplate verbiage. But in section B2, it's like, here's the other problems that we've discovered with the property that we will not be insuring. That's a very
Yes.
important section. So,
And sometimes the title company will just list what that recordation number is. And a few times I have asked the other title company to send me what those recordings are.
yeah.
And they seem a little annoyed, like it's none of my business, but it's important to know.
Yeah, yeah, isn't that funny? Annoyed that you're doing your job and what we're supposed to be doing.
Yeah.
Here is, and you're right, Joyce, your definition. Here's what I put. Fee title means the type of ownership giving the owner the maximum interest in the land, entitling the owner to use the property in any manner consistent with federal, state, and local laws and ordinances. So you're declaring that A, you have ownership, B, it's not encumbered. So that could take the form of liens and other things. And you're right. Just because there is a loan against the property does not mean you do not have fee interest in the property. But kind of important to know, because we run across people sometimes who will say, oh, I'm going under contract right now, and I have the right to purchase the property that I'm going to turn around and sell. That is a direct contradiction to the phrase there, and I have it underlined in red, that you have fee title to the property, not that you're going to get it. So be careful if you're representing a seller who's trying to play that little game, say this could potentially be a material breach in the contract because you made a representation that is untrue. Okay? Don't want to spend too much time there. That was for rehearsal. All right. Seller's disclosures. Let's dive in on this, right? Seller's disclosures, for those agents that don't spend a lot of time looking at their contracts. And again, I'm going to say this one more time. I don't expect you to be nerded out on a contract, but you should know the main ideas behind a section. So for instance, on seller's disclosures, I have a little blurb here, and it says seller's disclosures A through L, not just the SPCD form. These are potential material breaches to a contract. I'm going to tell you about an attorney and an agent, HOA, CC&R, finances, evidence of water rights and shares, push versus pull requirements. I'll come back to that. And building zone violations. How does that impact basements for about 80% of the basements in Utah? And making sure you have a paper trail. And then the last one, FERPTA. I just love saying that. Come on, everybody say it. FERPTA. It's just one of those words, right? FERPTA. Okay, so the
I
this,
did not. Yesterday, I did.
oh,
No, I'm good.
Colleen,
Thank
I'm
you.
gonna mute you. There we go. So one, this is the obvious one, and unfortunately, this is what a lot of agents think. They're like, oh yeah, they mean the SPCDs. Yeah, that's item A. If it's pre-1978 lead-based paint disclosure. And as you were just talking about, Joyce, this is an important one, a commitment for title insurance. That's a required seller disclosure. CC&Rs, HOA, budget, minutes, financial statements, it's if applicable, rental agreements, and then we get down to item I, evidence of any water shares and or rights referenced up above in section 1.4. So you have to provide the paper trail. If not, you're not giving seller's disclosures as you contractually agreed to. And then the last one, written notice of any claims and or conditions known to the seller relating to environmental problems and building or zoning violations. Okay. Oh, and then the last one, FERPTA, is just the Foreign Investment Real Property Tax Act. I will finish on that one as we round out this section. Okay, so when we talk about the water rights, right? And water is now the new liquid gold, as we mentioned last time going around. And when we talk about evidence of any water rights or shares, what are we actually supposed to be providing there? Anybody know? Dan, you want to take a stab at that?
What are we supposed to be providing as a seller to the buyer?
Yeah, so if we were
Well,
up,
if you're looking for, undeveloped land or, a parcel without a structure on it, AKA anything outside of a like traditional in a subdivision home, often you'll need to have some sort of water rights in order to operate what kind of whatever. It's a farm. I need to have certain water rights to be able to do so. It's a development. I need to have the water rights appropriate to be able to build a structure on there, right? So those are often the water rights that you're looking
who do you
for.
typically get water rights from, Dan?
Yeah, so you can get them from several places, typically from the seller. The seller will have often water rights to be able to do what they have done in the past on that property. So if
Who
you're
do they get them from?
well, so they get them from several different places depending on where you are, right? So you can get them from like the Provo Water District or the Strawberry Water District or whatever water district that governs the area that the property is located.
I'm in case you can't tell, I'm driving at something here. Who's top of the heap? Who do they get it from?
The state.
The
I used to
state.
get mine from the state.
That's right. That is the state engineer. The state engineer is responsible for all of the water in the entire state. And so Dan, what's Dan is saying is first there's issued rights. So I'm going to use Strawberry Reservoir, Strawberry water because it comes from Strawberry Reservoir. It's very common down here in Utah County. The Strawberry Water District or entity gets certain rights from the state engineer, right? It says you're entitled to X thousand acre feet of water. By the way, what's an acre foot of water? It's 1 acre, a foot deep in water. That is 1 acre feet of water. And so they secure thousands and thousands rights to thousands and thousands of acre feet of water. Yeah, millions, a lot. And in turn, they have the right at that point to turn around and issue water shares based on their rights. I'm painting with a broad brush, but this is generally how it goes. So that's a large entity like Strawberry Water. Now, you could be in a ranchette on the west side, out towards Lakeshore or some community like that that has a bunch of 5-acre ranchettes, and you need water for either agricultural or livestock or anything else like that, and you want to drill a well. You go to the same entity, the state engineers, the repository for all well permits, and based on that, you are then given a certain amount of water rights and or shares, right? I can pull so many acre feet out of this well, and then it starts to get a little muddy when sometimes you have a common well where you're sharing it with 2 or 3 or 4 neighbors or something like that. So the point here is not to go into a whole water discussion, but you're to provide paperwork verifying that you have access to the water that you're currently using. And if you don't, it is in fact a material breach to the contract. This is one of the points I wanted to make on Section 7. I don't know if you remember this, Dan, about 7-8 years ago down here in Utah County, we had a realtor that was going around with an attorney, and they were writing contracts, and because a lot of agents don't pay attention to the deadline for sellers' disclosures and not realizing all of the items that are required here. And they would put up, $10, $15, $20,000 of earnest money, and then they would put a crazy timeline for the buyer to provide all of the seller's disclosures, like 24 hours. And when they didn't do that, then the attorney would turn around and file a default notice against them and say, we want an equal amount of our earnest money as per Section 16A. We want $15,000. You're in material breach. Kind of a scummy thing to do, but they did it that way because they knew that sellers' disclosures in the courts are a material breach to a contract. So this is just like a fair warning shot across the bow to you guys. The things here are not insignificant. They are significant. They're super important. So pay attention to them and pay attention to the deadline.
Name
Hey, Matt.
names.
Oh.
Who did that?
I'm
I
not
remember
naming
that.
names.
Yeah, I remember that. Matt, what do you do when city and the state can't agree. So like Pleasant Grove has been seizing water rights from its residents, and the state's like, oh, we didn't know about that. We're not getting on board.
Yeah.
But then you try to sell the property and you can't because they're not agreeing because of what PG's doing.
It's a great question. We have that at Pablo Creek Canyon in some areas and some other places. Yeah, our job is not to be litigators and go, help the state and municipalities figure it out. We don't have the power or the persuasion. Our job in situations like that is to make sure we have a paper trail when we become aware of those issues, that we disclose it to the respective parties and say, hey, we have paperwork that says we have water rights to this. The city of PG is contesting that. The state says that they actually are our rights, but it's currently being litigated. That's our job.
Okay, thanks.
Yeah. All right. Now here's an interesting one. Look at item I. Written notice of any claims or conditions known to the seller relating to environmental problems. That would be like your soil tech and things like that, or it could be asbestos or other things. But the last portion, I find this one interesting. And building or zoning code violations. So if you build out your basement and you don't get a permit, is that a building violation? The short answer is yes, it is. And I have so many discussions on this because agents, I get a whole list of arguments on this. It's like, we've been doing this forever. It's not a problem. Yeah, we used to do commissions a certain way for a long time until, there was class action lawsuits, and then we got a national settlement foisted upon us and things like that. So don't take um, too much comfort in, oh, we've always done it this way and it's never been a problem. When I hear that, it's like, yeah, it's not a problem yet. Do you want to be the guinea pig? So in pragmatic terms, what should we be doing that in seller's disclosures? I would say when it comes to, hey, I don't remember the section in seller's disclosures, but have there been any additions? I would get ahead of the curve when people are excited about the property and say, hey, you know what? We finished out the basement in, 2016. We did not pull a permit with Springville City. Now, what are the potential outcomes of making that disclosure? Come on, this isn't hard. Savannah, what's somebody going to say?
Why didn't you pull the permit?
Yeah, you know what? We just didn't want to pay taxes. We didn't want to pay taxes on the extra square footage. Okay, there's one. Now, that doesn't mean I'm right, but I'm now ahead of the game as the seller because I've disclosed to you, and the obligation for you as the buyer is to do all test verifications that you deem necessary as the buyer, right? And I'm to disclose anything that's not readily discoverable. Now, somebody could make the argument, even seeing if a basement had a permit pulled on it is readily discoverable, but I would never want to hang my hat on that. Something I've told agents before, years ago, I actually had a listing. I had a buyer that was buying a listing that, the house was done really well. We all know the houses we're talking about, right? When you go into a basement, you can tell it's a homeowner special. And one of the easiest ways to tell is when you look at the tape and the texture job in the basement. And you don't want to rub up against the wall because it'll scrape off a pound of flesh because it's so rough. There's these tells that you just know this is a homeowner special. This was not the case on the one I was representing a buyer, but we did ask, right? We did ask. And the seller's like, actually, you know what? We didn't pull a permit. Like, well, whoever did the build out did a really good job. I mean, it was tight. It was done well. And we reached out to American Fork, and the city of American Fork, and asked them, what do we do about that? And they said, well, we will issue a retroactive permit for the basement. Did you guys know that? That's a thing, a retroactive permit. And I checked like 5 other cities down here in Utah County. Check your municipalities. I'm pretty sure they all have something like this because they always would prefer to get money from issuing a permit. And I said, oh, so how much more is that than just pulling the permit when somebody builds it out? They're like, oh, it's the same amount. And I said, wow. So what does the inspector do? He says, well, we go out and we kind of check the quality of the build, much like I was just talking about. If, on code, there's, electrical outlets at a certain height every 10 to 12 feet. And, there's things that they just look for, and they have things that can read in the wall and see where either copper is, the Romex, the wiring, or water and pipes and things like that. And it's pretty non-scientific. They look at the quality of the build, they check a few other things to make sure they're compliant with code, make sure you have like uh, um, smoke detectors and things like that. And if they're satisfied, they won't even do what they call an invasive inspection. They will issue the permit. Now, what's even better is if when the person built it, if they took like photos or video before they buttoned it up with insulation and sheetrock, that makes it even easier. But just know, in many cases, there's an avenue to get those resolved, okay? But again, if you're representing a seller, I would get something in writing just saying, yep, we didn't pull a permit. And then the buyers can choose to decide what they want to do with that, okay? FERPTA is important mostly because of the potential withholding consequences, right? So if somebody is a foreign person and they're selling a property, the IRS wants to make sure that they're going to get money that they are owed, right? And has anybody had this at closing? FERPTA withholdings? Really? Nobody? Huh. Anyway, the point being is if those funds are not
I have,
held.
Matt.
Okay,
This is
Chuck.
Chuck. Yep.
Yeah. How did that go?
You know what? It was fine because the seller was aware of it, and and I had asked him about it too, because I knew that he was from Norway, and they did withhold. I want to say it was 15%
That's
of
about
his.
the average, yeah.
Yeah. And he was he was well aware of just what it was going to take, and the process was pretty straightforward, but it did take him, 5 or 6 weeks or something to get his proceeds.
Yeah. Yeah. But here's the thing, if you're representing a buyer, you want to be super aware of this, because if those amounts aren't withheld and the seller owed money and then they leave the country, guess who's
Yeah,
responsible?
it's on the buyer.
It's
Yeah.
on the buyer. It's
Yeah.
on the buyer, and that can be a pretty penny. Okay, so just remember, all of these items in seller's disclosures are of significance, and we need to pay attention to them and the corresponding deadline. Now,
Can I pose a question on the, Chuck, you mentioned it took weeks for him to get his proceeds. So if we have a FERPTA withholding seller situation, we can't just then do a simultaneous purchase on something else. Is that correct? Those funds aren't available to move forward into a new transaction right away?
that's
You know
correct.
what? That would be yeah, that would be right. And I think that if a seller was doing a 1031 exchange, they would just need to, be aware of that and when would their funds be available. But it wasn't a problem, but you just had to follow the procedures with the IRS and,
Mhm.
and to file all the documents and whatever. And then they determined if they were, what they were owed for capital gains, and gave him the what rest was released.
Yep. Yep.
Okay.
Yeah, there's a sequencing and timeline. Until that's resolved, those funds are not available for anything.
And you
Right.
can't get that work done ahead of time with anticipated proceeds to receive the proper authorization and documents you need from the IRS. It has to
I don't,
sequence
yeah,
after.
I don't think so. I think that
Okay.
because he was where you have to go, it has to close, the money gets held, it gets verified. Is that your understanding, Matt?
Yeah, this is what I love about Joyce's question. It presumes that the government is terribly responsive and helpful to us.
Well, but in this particular case, and I think that with the FERPTA withholding, it's the government was pretty spot on with getting the funds released, but it was a simple process, but it took several weeks.
Yeah, the problem is you hit on the key point. It actually has to close so they
Yeah,
know what the gain was on the property so that they can then do calculations if anything's owed, et cetera, et cetera. And that's
yeah.
why the government wouldn't be able to future pace and say, yeah, this is what we think you're going to owe.
Right.
So
And it
one
was,
more question
yeah.
then. So the title company is required to hold all of the full amount of the seller's net proceeds
No.
or just a
Yeah, there's a
ratio?
calculation. If you Google it, it depends on the year of the property, et cetera, but it's usually around 15%.
Okay,
Yeah, and that was the number on his for whatever reason. Yeah.
Uh-huh.
okay.
Yep. Okay. So,
Thank you.
yeah, good questions. All right. So we're coming up. The blue is a major section anytime you see a blue highlight, right? So buyer's condition of purchase is all of Section 8. Before we quickly dive into that, I want to jump ahead because it's important to understand this. And it's Section 10, not the home warranty portion. We don't need to cover that. It's the as-is condition of the property, right? This is like so substantial. If you want the history, it's helpful sometimes when you're talking to your sellers or your buyers about this. And the storyline is this. Hey, prior to 2009, right? Our state REPC had the sellers giving expressed and implied warranties regarding the mechanical, the electrical, the plumbing, and finally the Division of Real Estate said, this is bull. We're tired of dealing with the disputes on this. We're going to fundamentally change the contract and we're going to put this section in. Section 10.2. I'm going to quickly read it and then I'll finish. Buyer acknowledges and agrees that in reference to the physical condition of the property, A, the buyer is purchasing the property in its as-is condition, what? Without express or implied warranties of any kind. B, the buyer shall have during the due diligence, as referenced in Section 8.1, an opportunity to completely inspect and evaluate the condition of the property. And C, if based on the buyer's due diligence, the buyer elects to proceed with the purchase of the property, what? The buyer is then relying wholly on the buyer's own judgment and that of any contractors or inspectors engaged by the buyer to review, evaluate, and inspect the property. And oh, by the way, this section shall survive closing. I missed that one. Okay, so this is a very significant section because it's the starting point for the contract, right? And it basically says, hey, buyer, beware. Your job is to check this out to your heart's content. So now I'm going to quickly go back to Section 8. And Section 8 was the trade-off by the division since the sellers no longer had express or implied warranties of any kind. They in turn said, well, then we're going to give the buyers some really powerful contract language. And we know what these are, right? The due diligence section. Now, I highlighted these on my documents because they're really important. Back when there was a lot of offers coming in and we were competing, we were having people choose to say, oh, our offer is not conditioned on the buyer's due diligence. Well, you have to pay attention to the words in the contract because it says, if checked in the affirmative is, then all of the sections that follow in Section 8.1 apply. Otherwise, they do not. Dan, what does that tend to mean about going on even if you're not going to use this as a way to cancel the contract, your buyers still want to go on and look at the property and have a home inspector come on. What does this mean for them?
That the sellers might be able to say no.
Yeah. Yeah, because right here it says, right, this is the sections that apply if checked in the affirmative. Under Section 8.1a, seller agrees to cooperate with buyer's due diligence. If you check is not, then this section no longer applies. The seller does not have to cooperate with the buyer's due diligence. And we have had several instances where the buyer says, sorry, you said is not. You can't come on the property. They're not doing anything outside of what's in the contract that everybody agreed to. So this is why it's important to know the key portions of the language and how it can kind of flip the script on certain things. But let's assume that our buyer did check is. This section, due diligence items, is super important, so I put it all in red, right? Because the opening section says, in addition to the seller's disclosures, which we just covered, the buyer is able to do any other tests, evaluations, and I love this one, verifications. The word verification has a certain ramifications. So something's there, they have a responsibility to make sure it's still there functioning, etc. of the property deemed necessary or appropriate to the buyer, such as, and then they go through a list. I'm not going to go through all of them, but hey, geologic conditions. No, you can't come back and say, oh, I didn't know we were on an earthquake fault, like the whole Wasatch Front is. Really important. Square footage, acreage, availability of homeowners insurance, flood insurance, location of property lines. Another big one. Regulatory use restrictions. Oh, I thought I was going to be able to use this for an overnight rental. Whose job is it to find that out, Dan?
It is
That's
the buyer's
It
job.
is the buyers. And then, as if this opening portion wasn't powerful enough, they come back at the end and say, and any other matters deemed material to the buyer in making a decision to purchase the property. Wow. Super important section, right?
Hard to get a whole lot broader than that.
It is a big umbrella, right? So going back to section 10.2 says the seller is off the hook, right? As far as express implied warranties. But now all of a sudden we have this opening paragraph that says, oh, and by the way, the buyer, you're responsible for all this. So where is the positive for the buyer? Oh, it's right here. If you see anything related to this, and by the way, this is not an exhaustive list, it's just a suggestion of some key ones. That's why they put the catch-all right here. Anything else you as the buyer deem necessary. If you see anything that you like and you determine in your sole discretion. Let me give you a translation in case you haven't heard me say this before. When it says at your sole discretion, it doesn't mean you have to hire an inspector to do it. It doesn't mean you have to actually have proof of anything. It literally means for whatever reason you want as a buyer, your sole discretion, you can cancel the REPC as long as you do it by the deadline. And nobody can object to it. This gets in front of a judge in court. It's like, and anybody throws any argument at this, it would be like, hey man, did you read the contract? It says right there, it's at the buyer's sole discretion. So this is the trade-off. 10.2 got the seller off the hook, but section 8, starting with 8.1, gave the buyer huge power, big enough that you can drive a truck through it to get out of the contract if you want, right? Super powerful. Okay.
Matt?
Section 8, yes.
I think I have the king of all buyer discretion excuses. Years and years ago, under contract with buyers, and they called me one morning and said, we both had a terrible dream last night. We cannot buy that house because they had two young boys at the time. They said, we believe we will lose one of our sons to death for whatever reason.
Covered.
Yeah. So
Covered.
I canceled that contract, and those sons are now grown and married, and life
Well,
is
thank
good.
goodness
But
they didn't buy that
wasn't-
house.
Yeah.
Yeah,
So
I mean,
anyway,
if you want to be ridiculous, back in the day when I was selling on a regular basis, I would tell the buyers, honestly, if you came in and you didn't like the way the house smelled, right? You just like, what'd they cook in here? You're out. Nobody can even question it,
yeah,
right? Okay.
yeah.
But the key is you must do it, what, in writing by the deadline for due diligence. If not, all bets are off, because that's what section C says. If you fail to cancel or resolve, then what? Buyer shall be deemed to have waived their due diligence condition, right? Pretty straightforward. You've got all the power up until the deadline, and if you go past it, you lose the power. You've waived your condition. All right, section 8.2 is not one that has at the buyer's sole discretion. This is the one out of the 3 that actually requires a paper trail. If you're going to cancel on appraisal, which, editorial for a minute, I don't know why I ever would cancel on appraisal if I still had my financing condition. Why? Because the financing condition still has the term at your sole discretion, and it's even more powerful if you're not satisfied with the terms and conditions of the loan. Not qualified. I get this all the time. I got this from a real estate attorney one time who's like, you're just your buyer is canceling as a secondary due diligence. And I said, Paxton, well, shoot, there's his name, sorry. And Paxton's a friend, and we had a good laugh about this afterwards, but he was kind of ticked off at the time. I said, I have a job and my agent has a job. If we're given a lawful legal request from our client to cancel because, in their words, I'm not satisfied with the terms of financing, we have a fiduciary of obedience and we will send over the cancellation. And no offense, you're an attorney. You should know there's literally nothing you can do. You and I may agree that they may be using it as a secondary due diligence cancellation, but it's irrelevant. It's irrelevant. So remember, section 8.1, your due diligence has sole discretion. Section 8.2 appraisal, you actually have to provide a copy of either the appraisal or the valuation notice. Section 8.3 is back to at your sole discretion. Okay. Super important. So you guys see the balance there, right? The state said, let's make this fair. Sellers no longer required to do any warranties, express, implied, or otherwise, but we're going to fully equip the buyer within guardrails, meaning the dates for section 8.1, 2, and 3, they can exit the contract. Pretty much ironclad. Now, before I finish up on this, I would just say this. I've had this argument many, many, many times with other agents and brokers. Much to like Paxton was saying, well, they're just using that as a secondary due diligence. Let me show you how this plays out, even though it's not required because it has sole discretion. But if it came back after the due diligence was done, became aware that there was a special assessment or something like that they could have discovered, maybe should have discovered during their due diligence, is it still covered by whether they're satisfied with the terms of financing? Well, we thought we had a maximum of $2,000 we could pay towards our housing costs every month. And with the special assessment, it's now going to be $2,200. Does that change how I feel about being satisfied with the terms of financing? Yeah. So, I get the argument, but they should be wise enough to know the contract well enough themselves that until you pass this deadline, if it's checked in the affirmative, all bets are off. You really shouldn't have taken much comfort that the contract had a guarantee of going through. Okay? Make sense, everybody? All right. I'm going to rattle on here. Section 9 is the addenda. You'll notice something here. Anybody notice what's missing that used to be in Section 9? The lead-based paint disclosure used to be a checkbox here. And I went to the attorneys for UAR. I'm like, this is an addenda section, not a disclosure section. Why do you have the lead-based paint disclosure in as a checkbox for an addenda? Right? Now, if it was the lead-based paint addendum, it'd be a different story. This section for other, has anybody on a regular basis use that section when they're writing an offer? And if so, what do you put in there? Yeah, Dee, go ahead.
I started putting the MLS sheet that confirms everything that's included, especially on this last one because they did a remodel and they had listed all of the names, the brands of everything. And so I wanted to make sure that that carried over into
Oh
the contract.
man, I'm so glad you brought that up, right? If, let me jump ahead for 2 seconds so you'll understand what we're saying here. Section 14 of the REPC says that the REPC, its addenda, and attached exhibits, right? So D, you put in there, check other exhibit 1, which is a copy of the listing. Therefore, all of the terms that are in the listing now become contractual. Without that, they're not. And here's why. Section 14 says, in addition to those items, and assuming D had not done what she just said she did, the seller's disclosures, those items constitute the entire contract between the parties and what supersedes and replaces. Super powerful language, you guys. Section 14 is a beast. Supersedes and replaces what? Any and all prior negotiations, representations, that would include the MLS, by the way, warranties, understandings, or even contracts. Because I've had people argue, well, we had a verbal contract. Well, go read section 14, because you agreed to any other contracts previously that aren't part of this contract, they're off the table, whether verbal or otherwise, right? So those things are out. It's because they were superseded and replaced. They replaced all of that list of items. So I'm not saying this so that we can go beat somebody up and say, look, I know my contract so well, you're an idiot. That's never a good play. But it's good for us to know, right? So that when the other side comes back and said, well, you guys said, or the MLS said, or we had talked to the seller and they agreed to, the starting point for that conversation, D, you're going to be my guinea pig, is like, D, honestly, I'm excited that we're doing this deal together. And as professionals, I just want to have this conversation with you quietly. I don't even propose that we should have this directly the way I'm talking now with our clients, because it could upset them. But you and I need to be in clear understanding. Section 14 says the following: supersedes and replaces all of those things. So if your client is making reference to those things, I hope you can help them understand section 14 so that this isn't an ongoing problem. Right? I'm not being a jerk. I'm referencing back to the section politely. I'm telling them that we're the pros. We should be the ones able to handle this in an intelligent way. But I've also fired a shot across the bow saying that's not going to play. Right? It doesn't matter. You know, a lot of times we have, well, in the remarks of the MLS, it says X, Y, and Z. Any and all prior negotiations, representations, that would be your MLS stuff, right? It's off the table. If you didn't include it in the included sections, it's out. Unless you did what D just did, and you went up to section 9 and you checked other and you said exhibit 1, copy of MLS data, MLS listing dated such and such, right?
Matt, I think people have to be careful what they check as included as well, because on this condo, they checked a microwave. And when we went through on the home inspection, there is no microwave. So they're gonna have to produce a microwave because we fully expected a microwave to be
Hold
there.
on.
But home
There's
doesn't have.
ooh, you just hit a good one, D. This is a reminder, and I'm going to make this quick because it wasn't on the schedule, and I want to make sure we finish out. When you go to the included sections, there is some very important language, right? Right here, right? The following items that are presently owned and what? In place, right, on the property. So this works a couple of ways. If it's not there in the first place, even if you wrote it in, sorry, that wasn't there in the first place, and the contract language is very specific, right? Not only that, if it was, I don't know, something that was leased or rented, like a security system from Vivint, and it was at least, that's not owned. And so you should not have the expectation that that would be included. What's the answer here? Ask a lot of questions. Hey, I see you guys have a security system. Is that owned or leased? You know, is there, you know, whatever, you can fill in the gaps, but this is important language that you need to remember. Okay.
Hey,
right.
Matt,
Yes.
Haley here, really quick question before we leave that. It seems like on the buyer side, you know, that's a nice, thorough, detailed, you know, kind of thing. But I would think on the listing side, as a seller, you would be less excited about the additional liability and the exposure that that gives our sellers and us as a brokerage.
If what?
Well, if you take a marketing piece, which is the MLS,
Yeah.
which is non-contractual, which is a marketing piece, and all of a sudden you flip it into a contractual obligation.
Yep. So that's a great
Which
point,
for the
Haley.
sellers is a whole different level of exposure.
I'm glad you brought that up. If we're representing a seller, we should be a little cautious, more than a little cautious.
A lot.
Maybe say, you know, we're countering your offer. We're going to exclude that after I have a conversation with D. Well, what is it exactly from the listing you want to put in? And let's put it in section 1.1. We don't want potential exposure of including that. But if you're representing the buyer, man, that just puts you on steroids. So anyway.
Yep.
Okay. Rattling back here, checking my time real quick. All right. So we went through section 8. We did section 9, section 10, we'd already covered the as is condition. So just so you guys know, when we're dealing with a lot of situations, these are the ones that section 10.2 and all of section 8 tend to be very common, right? Because one represents the seller, saying, I'm off the hook, no express implied warranties of any kind. And the buyer in turn, and the seller should know that the buyer has these exits to the contract. These are fundamental to the very nature of the contract that we utilize. There's a lot of tangent information, but these are like, I think, some of the pillars of the contract. Now, Section 11, I made a note here. Are you professional? Are you a professional in making sure you do this, meaning the final pre-settlement walkthrough inspection? Many conflicts over this section that can be resolved more easily before the deal funds. Oh my gosh. Included items, excluded items, things like that, the condition of the property, water damage. And you know what? I don't know what it is. Some agents are like, yeah, nothing probably changed, so I'm just going to bypass doing the final walkthrough. Oh my gosh. All of the work you put in, A, finding the buyer, B, finding a property, C, going under contract, negotiating things, dropping the ball at this phase of the contract, probably in many instances is going to mean you don't have a repeat and refer client. Because you didn't do your job. You kind of got lazy towards the end, right? And so I look at these things like section 11, be like, this is where I reiterate and secure my legacy as an agent with the client, right? I stuck through the whole thing. I wanted to make sure there wasn't any damage. There were the items that were supposed to be included were included, and if not, we haven't funded and recorded yet. Guess what? We have stick left. We stick and carrot. They want the money, we control it, and we've got some leverage. If we don't do that and we wait until it funds and records, not that you don't have any leverage, but it's a lot more painful at that point to do it, and your client's probably not satisfied with you and they feel like you dropped the ball and you're not going to repeat and refer. Okay, that should be pretty straightforward, right? Just remind yourself, don't get contract fatigue and bail out at the end. All right, changes during the transaction. My note here is do not rely on texts, emails, conversations, etc. There's explicit requirements that the two parties signed to, right? That said, if we're going to make changes, right? They must be done in writing. This is actually referring more specifically to alterations to the property and encumbrances and property management agreements, but it also dovetails with section 18. Any notices or changes have 3 requirements: must be in writing, signed by the party, and delivered. Okay. Authority of the signers, one of my favorite ones. And I get, if you've dealt with somebody who has a trust, they're a trustee of a trust, they're an executor of a will, there's an LLC, whatever the case may be. I have people all the time point to me and say, yeah, the buyer at the top is the ABC Trust, and I'm Bob Jones because I'm the trustee, and I just signed as Bob Jones. And when I tell them, actually, that's not the way you're supposed to do it. In fact, when you go to title, they will have you sign in a very specific way. And I say, you really need to sign this way. And this is the argument that I get. Hey, section 13 covers me. If the buyer or seller is a corporation, partnership, trust, estate, limited liability, or other entity, the person signing the REPC on its behalf warrants his or her authority to do so and to bind the buyer and seller. And so they use this as an excuse or a rationale why they don't have to sign a certain way. But if you understand what's being said in section 13, that's not what it's saying. If I sign, for instance, correctly, Matt Barton, trustee of the Matt and Nancy Trust, that's the way you should be signing. There's nothing here that says you're not to sign it the right way. It just simply says, if I state that I am the trustee and I sign the right way, I'm in section 13, I'm contractually affirming that I am the person who is the trustee. It has no bearing whatsoever on how we sign. Is everybody understanding what I'm saying there? This is not a reason, a rationale, an excuse to not sign it the right way. So for a trust, I'll use my example.
Sorry,
Yeah, go ahead.
Matt, can you rephrase that? Because in my brain, what I'm hearing you say is it's okay if I sign as Parker Smith, if I'm the executor of a trust or something like that, as long as the other documentation confirms that I'm a signee for the trust.
Right.
Am I misunderstanding that?
Yes. So what I'm
Okay.
saying, so what I'm saying is people who want to just sign their name, just Matt Barton, not Matt Barton, trustee of the Matt and Nancy Trust. They say Section 13 allows me to just sign my name. That's not what Section 13 says. What Section 13 really is saying is if I sign Matt Barton, trustee for the Matt and Nancy Trust, I'm positively declaring per Section 13 that I'm actually the trustee.
Okay.
Right? It has nothing to do with, oh, I don't have to sign that way. That's a lie. So my point with that, Parker, and I think we've had this discussion, a few of you on the call. If uh, Matt and Nancy Trust is the actual buyer, and I sign at the end as just Matt Barton, even though I am the trustee, that's the equivalent of your name, Parker, being the buyer and me signing where the buyer is supposed to sign. It's two totally different people.
Got it.
And that's the way the law looks at it, whether it's a trustee for a trust or a principal for an LLC or a partnership or anything else. And so the general format to sign correctly is who am I, the actual person signing? What is my role or authority? And for what entity? Matt Barton, trustee for the Matt and Nancy Trust. Matt Barton, president, Barton Building Realty Co. And any of you that have had this experience at closing at a title company, that's exactly how they're going to have them sign the documents. Huh, I wonder why. Because legally, that's what's required. So if we want to have a solid contract that doesn't have the loophole of potentially being invalid, much in the scenario of Parker's the buyer and Matt Barton signs as the buyer, well, that's an invalid contract all day long. Right. And so to avoid that, make sure people are signing the right way. The takeaway is don't use Section 13 to say I don't have to sign the right way. Okay.
Is there a blanket, like, can we just create an addendum that says Matt Barton, trustee blank, can sign as Matt Barton? Like, I'm just curious. I don't know. I mean, it's not that big of a deal, but I'm just curious what the runaround is for, like, what you're seeing people use as a runaround for that.
Yeah. And I tell them my job is to tell you how you can get your butt in a sling. And, you know, in the day and age of digital signature, all I have to do is one time go in and say, who is the signer? Matt Barton, trustee, Matt and Nancy Trust. I don't have to keep typing it over again. I click, there's the signature, click, signature, initial.
Yeah.
So it doesn't carry a lot of weight with me for people who are like, oh, that's so much work. It really isn't.
Matt, you just
Yeah.
have to remember that the signature line and the initials space is going to have like 13 letters, and the line for the signature is going to be like 6 inches long across the page. So you just have to plan for that.
True.
When you're putting in all those signatures and initials to sign. So
That's
give
a great
yourself
point.
space.
That's a great point, Giselle. So it doesn't run into other signatures or texts or other things.
Yes.
And just hope people have a really short trust or entity.
Yes.
Okay, how are we on time? We are out of time. All right, so we made let's at least go to default real quick. Mediation, pretty straightforward. My comment here is I'm not mandating, I prefer to check may on mediation. Here's the simple rationale. If you check shall, and both parties are pissed at each other and mediation isn't going to move them off of their position, then everybody just had to pay for mediation and had to show up, so they're not in default of contract, and the mediator just made $500-600. And now your client's more pissed off. If they check may, it only applies if both parties feel like, yeah, mediation is going to help. It doesn't rob them of the opportunity to litigate if they want to litigate. And oh, by the way, when we talk about attorney's fees down here in Section 17, however, attorney's fees shall not be awarded for participation in mediation under Section 15. So another reason why I don't like the shall. But you can, You
Mm.
can put shall. There's nothing wrong with it. I just don't prefer it. Okay, last one is default. If section 8 and section 10 are materially significant, then section 16 is the teeth of the contract, right? And I get this all the time. People remember the first resolution, which is, oh, you can cancel the REPC and retain the earnest money deposit as liquidated damages. That is only one of the remedies. The other one is keep the earnest money in the trust account. It's a requirement of the contract if you're going to sue for performance. So don't come to me, don't write a contract that says earnest at the front end, earnest money to be released to the seller, and then come back later and want to sue for specific performance because you have just wiped out that alternative because the earnest money was not retained in the trust account. So there's consequences to what we do. It's important for us to know those consequences. And then the third one, so A and C does have earnest money going out of our trust account, and C is the option where you sue them for other damages. Give them the earnest money, file a lawsuit, sue them for, the buyer that you missed, the fact that you had to do 6 more months of mortgage payment, blah, 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 whatever the damages are. The remedies are effectively the same for the seller, but just in reverse. The important thing I think with this to know is, in most cases, or at least in many cases, yeah, the first one is the easiest one, right? Earnest money is the cheapest one in most situations, unless, it's $1 million earnest money, then it's not so cheap. But for most of our transactions, $5, 6, 7, $10,000, yeah, that's gonna sting somebody, but it's for most people, it's not gonna destroy their finances, right? If it goes to litigation, anybody done the litigation route? And I don't mean like in small claims, I mean like in district court. District court, your filing fee is north of $3,000. You do have to have an attorney. You're, depending on the load of the court, you're 4 to 6 months out before your first hearing. And if you don't know how those things go, it's kind of the preliminary hearing where who's suing who for what and the damages, and okay, great, and let's go do discovery now, and that takes forever, and people make all kinds of excuses to delay, delay, delay. Meanwhile, the property is tied up in litigation and you're paying attorneys their hourly rate. And then eventually you go to court. And Dan and I think we were talking about this the other day. When you've worked with enough attorneys, you'll hear a common theme. They'll be like, really, do we want to litigate? And there's some version of this story. And it's, I've had situations 10, 15, 20% of the time where we are well documented, where we are in the right, and we go to court, and whether it's a crazy or sympathetic judge or a jury or whatever, it goes against us. And so I want to fight for my agents and their clients, but I take an equal responsibility because I have gone down this path many, many, many times over 18 years as a principal broker. Oh my gosh, if you can steer clear of litigation, it's a good day. Even if it costs you money, it's going to cost you less money in almost every instance to avoid the litigation. And so if I ever have that conversation with you, promise me you'll remember this, that I'm not doing it because I'm weak in the knees. I'm literally looking at this going, wow, right now I think you're running on emotions, you and or your client, and I'm trying to steer you clear from something that will consume your life for 6, 12 months and has the potential of not going the way you think it will go, even when you're right. So that's the negative part of this default. The good news is when we're talking to somebody, and again, it really does matter on how you present this. If Giselle was on the other end and we're having a dispute, I'd be something like, Giselle, I have so appreciated working with you, and I know you're doing everything you can, but we've hit this impasse, and if we don't get this resolved, if your people go forward, my clients, they've kind of intimated to me that they will go the litigation route, and I'd hate to see that happen because I know from experience what that could be. You and I will get lumped into this. Our brokers will get lumped into this. Quite often, in parallel, somebody will file a complaint with the division because we're now litigating. And Section 17 now comes into play. Because if it does go litigation, the prevailing party, it's already been agreed to, they're going to have their attorney's fees and legal costs paid for by the non-prevailing party. So it's not just the earnest money. It's not just the damages. It's just not paying, for your own attorney. It could be both. So I hope we can get to some level of resolution. Right? It's never a pleasant conversation, but at that point, it's trying to minimize it so that it's not as painful, and trying to get your counterpart on the other side to carry the message to their respective client. Let's try and avoid this. Does it always work? No, it does not. But man, it is well worth the effort. Just because this is why I say everything I just said, and that we're going to wrap up on this point, is because as agents, especially agents who've never gone this route, we get target fixation on, but we're right. We're right. And you know what? I don't disagree with you in most cases. I know you're right. But it becomes a question of, are you ready for the pain and the cost and the time to have somebody else say you're right? And you know what? For some clients, they're willing to do it. But for most of them, they don't understand. And if you can shed light on that and work to resolution and say, why don't we try mediation first? Right? That's probably a good day. We'll finish on that. Next week, I'll just wrap up really quickly, or next 2 weeks from now, I'll wrap up the rest of them. This is really, if you didn't attend any of the contracts and negotiations training except for the REPC, I'm glad you're here for this one, because it is fundamental to what we do. I hope you take away from this, by my tone, I know the contracts pretty well, and I could get in a lot of fights if I wanted to, but I really try and steer clear. If, on the other hand, we get somebody that's obstinate, I'm going to beat them up a little bit. Right, Dan? I see you smiling and laughing. You know what I'm talking about. I will go to the mat for you. Oh, I need to coin that phrase. I will go to the mat for you. But I owe it to you, and I owe it to your clients, to have a high degree of pragmatism balanced against their wishes and needs. And I hope you all have that same attitude. There's so few percentage-wise agents who can get over their ego and be a true, like, shepherd, Sherpa, guide, leader in the transaction, not only for your own client, but for the agent and their client on the other side. That's when you know you're a pro. That's when you know you're a pro. So I'd encourage you to do that. And I appreciate you guys being on the call. If you want a copy of the new marked up REPC, just let me know. Send me an email. I'll shoot it to you. Otherwise, I hope you have a great week. Any questions? All right. Thanks for being here.
Thanks, Matt.